Senate Democrats introduce a new take on the assault weapons ban. Plus, Maryland shall issue President Mark Pennak on his group's 2 recent court victories. That and more on this episode of the Weekly Reload Podcast.
No, the devil's got no hold on me.
All right, welcome, ladies and gentlemen, to another episode of the Weekly Reload Podcast. I'm your host, Stephen Gutowski. I'm also a CNN contributor and the founder of thereload.com, where you can head over and check out our Black Friday sale, which is still going on right now. It'll be I guess, at the end of today on when this goes public on Monday, but it's 20% off sale. And yeah, I mean, we don't do sales very often, so you should check that out, because if you get a membership, you will get exclusive access to hundreds of pieces of news and analysis that you will not find anywhere else, that will keep you up to date on what's going on with guns in America. This week on the show, we are talking about the latest developments in Maryland, where we've seen 2 significant federal court rulings dealing with the Second Amendment. And to go over that, we have the president of Maryland shall issue, who is the counsel in both of these cases, Mark Pennak, with us today. Welcome to the show, Mark. Thanks for coming on.
Thanks, Stephen. It's a pleasure to be here.
And can you tell people just a little bit more about yourself and Maryland shall issue for anybody who doesn't know?
Sure. Maryland shall issue is a nonprofit 501c4 advocacy group. We're nonpartisan. We don't take sides in partisan debates. We're a single track, single focus on gun rights in Maryland. And our members include thousands of people of all political parties and all political persuasions who are interested in pursuing their rights to self-defense under the Second Amendment and other rights that are preserved by federal and state law. So we exist to defend those rights. As to me, I'm a lawyer and have been for 48 years. I started out in big firm private practice in D.C. and moved to the Department of Justice, where I litigated cases in the Courts of Appeals and the Supreme Court as part of this, as representing the United States in that Department of Justice. And I retired from there, and I've been litigating ever since as counsel for and Maryland shall issue and private parties. So it's I can't get it out of my blood. I'm afraid I'm a lawyer to the day I die here.
Well, you've had a couple of recent successes here in these cases that you guys have filed against a state law and a county ordinance that dealt with handguns in both cases. The first major ruling we got deals with Maryland's, I think they call it the handgun qualification license. Is that
yes.
right?
And HQL.
Yeah. Pistol purchase permit would be another way of terming it. But and federal court struck down this law as unconstitutional because it doesn't pass the historic traditions test set up in New York State Rifle and Pistol Association v. Bruen by the Supreme Court last year. Can you just give us a summary of what the ruling was?
Sure. The handgun qualification requirement in Maryland is truly onerous. Not only did you have to have your fingerprints taken, but it had to be taken only by a certified live scan vendor, of which there are very few in rural areas. It had to do 4 hours of training, but the training had to be by a state certified by the Maryland State Police instructor. You had to go to a range where you can fire 1 live round. In most of urban Maryland, you can't fire a live round legally except on a range. And in most of urban Maryland, there are very few ranges. So you have to find an instructor who had access to a range and pay the range fees. So you had to do all of that, pay $50 application fee, pay for the training, which it can be up around $200, then pay for the fingerprinting, which is around $75 by the time they're done with it, because that's done by a private vendor and they're free to set their own fees. And then by the time you're done, you had to wait 30 days, up to 30 days, for the Maryland State Police to approve you in order to have the license, which then would permit you to do the same thing over again. And essentially, before you can buy a gun, you would then have to submit your handgun qualification license to the FFL, who would then submit that application. It's called the 77R process, after Maryland's form. Goes back to the state police, where they do another background investigation, the same one. And you have to wait 7 days, assuming that it's not disapproved, before you can pick up the handgun. So it took months to go through this process. Months. And no state other than Oregon has such a process. It is extremely burdensome. For example, there are no ranges in the city of Baltimore. So if a city resident wants to get a handgun qualification license, they would have to leave Baltimore. And that sounds like, so what? But there are a lot of people in Baltimore who don't have cars. And the hundreds of dollars of costs associated with this process basically disenfranchise the poor or the less capable people with less means from enjoying Second Amendment rights. Now, the court held, and I think properly so, that part of the right to keep and bear arms includes the right to acquire them in the first place. You can't bear or keep something you can't acquire. And the court held that expressly, and that seems to be perfectly correct. So under the first step of Bruen, that you have to see whether the text of the Second Amendment actually covers what you're complaining about, the conduct. The court clearly held, and quite correctly, that the right to acquire is indeed implicit in the text itself. And after that, then it's simply a matter of whether or not there was an historical tradition and of such kind of permission to acquire regulations that existed during the founding or anywhere in the history of the United States. And there simply isn't, and nor did the state even attempt to show it. So it was a straightforward application of the text, history, and tradition test that Bruen actually articulated, and it seems to me perfectly correct.
Yeah. There's a couple of things in there I want to dive into real quick. The first part is, I do think this is one of the first cases where I've seen a federal judge address what I've called the one weird trick that plaintiffs hate theory of Bruen, which is this idea that beyond the literal keeping and bearing parts, where owning and carrying, essentially, nothing else about firearms is protected, and you've seen this employed a couple of times. It's kind of honestly,
they tried it in this case.
Pretty lazy arguing. But I think this is the first time I've seen a federal judge actually, respond to this, and it doesn't take a whole lot of, brain power to understand that in order to keep arms, you have to be able to acquire them in some way, right. And therefore he found that there are Second Amendment protections for the acquisition of firearms, right?
So this has been addressed in other cases in the context of privately made firearms. Yeah. And one judge has held, and other judges have held to the contrary, that there is no Second Amendment right to manufacture your own gun, even though the history of the United States is full of examples where that's how firearms were acquired. Indeed, the entire colonies were basically homemade guns being made at home or by small shops. So that really has implications elsewhere, because the acquisition doesn't mean just going to an FFL and buying one, and acquiring other means as well, including making one.
Yeah, I saw this also come up with Colorado recently. Their 3-day waiting period was challenged, and the federal judge in that case, the district judge there, upheld the 3-day waiting period on this idea that basically the Second Amendment doesn't protect the acquisition or sale of firearms at all.
Yeah, it's Rocky Mountain case.
Yes. So it's interesting. It's interesting to see a judge. One of the first examples that I've seen of a majority rejecting this idea and explaining why.
Well, and it's the first Court of Appeals decision to do so, but it has other applications as well. For example, in the city of Chicago used to argue that there's no right to have a range in the city limits because there is bear on keeping arms, and the Seventh Circuit has held, in fact, implicit in the right to keep and bear arms is the right to become proficient and remain proficient in their use.
Yeah, I should say post-Bruen. This has come up previously in federal courts where it's been roundly rejected. The idea that the Second Amendment doesn't apply to anything beyond keeping and bearing.
Right.
Literally.
So that's step one of Bruen. That's right. And a solid argument can be made that the right is not strictly limited to keeping and bearing arms that you already have.
Yeah, I mean, did you I wonder if this got litigated at all in this case, because, obviously the ruling is pretty straightforward on this point, where I think it's like a paragraph, basically. It just explains that in order to keep arms, you have to be able to get them in some way. And so therefore the text of the Second Amendment is implicated by this handgun qualification license process that you just described to us.
Well, it was a major point that the dissent made in this case, the HQL case, because according to the dissent, Judge Keehan thought that the Second Amendment right only protects the right to keep firearms permanently, or it would only bar statutes or laws that ban possession. And that's a very dangerous notion as well. And she wanted to remand the case to see what the practical implications, whether or not the effect of the HQL litigation, the requirement that is, actually kept people from acquiring. Now, we know that, in fact, it did, because we have record evidence of thousands of applications being made to the Maryland State Police for this handgun qualification license that were never finished, presumably because the applicants simply couldn't afford or couldn't make time, or otherwise were unable to go through all the hoops. And hoops is what the state called it in oral argument. All the hoops associated with getting the acquisition. I mean, there's no doubt to me, and I was there in 2013 when this requirement was adopted in the state legislature, that the whole purpose of this was to discourage the acquisition of handguns. I mean, it's intended to be an obstacle. And then the state police piled on to that this requirement of a one live round. Now, I'm a certified instructor, and one live round is of no instructional value whatsoever.
Right.
I mean, the whole thing is silly if you want to actually show competency in handling a firearm. I mean, you can do that without ever firing a live round, but you certainly don't require any level of proficiency by firing one live round, especially from a handgun.
Right.
So it was intended to create an obstacle, because access to range is limited. And the legislature knew that most ranges in Maryland are privately owned, usually by clubs, and not accessible to the public. So it created the obstacle purposely.
And I wonder, if you got into this argument at all, because the reason I call this one weird trick is that it's essentially saying that you can ban the manufacture and sale of guns. You just can't ban the possession or carry of them. And that seems fairly obviously problematic, because it would make the Second Amendment effectively pointless.
I would say it's idiotic myself, because it simply doesn't survive even a moment's worth of contemplation, just for that reason. So to ban the sale, okay, how are you supposed to get it? Well, you could ban gifts too, and the HQL did. You can ban the receipt, which what they did as well in the HQL statute. So how are you supposed to keep and bear anything if you can't acquire them? I mean, it's just crazy. You're going to ban manufacture? Well, all right, then how are you going to even get to the point where you can acquire anything?
Yeah. Did it come up at all? There have been, I think Eric Rubin is a well-known scholar, law professor, who's talked about this point previously, that there may be some sliding scale here of protection for the further you get away from keeping and bearing. Did anything that complex come up, or do you expect it to come up in future appeals to this case?
No, it didn't come up at all in this case. In fact, the state pretty much conceded that the right extended to the acquisition, and their whole focus was on the second step of Bruen, which was whether or not there's an historical analytical analogy to the restriction.
Do you think that might come up in the next step of this case if it does get appealed?
It might, but the state has pretty much waived it, in my view, by not bringing it up before.
Okay. So the focus here is essentially almost entirely on the historical tradition aspect. And in that sense, they didn't offer any actual explicit analogs at argument?
Because there aren't any, and they didn't. And they confessed at oral argument that, in fact, they were unable to find any historical analog from any time period that required governmental approval permission, if you will, to before there was anyone allowed to acquire a firearm. They relied on the militia statutes at the time of the colonies to show that training could be required, but I think the majority quite properly pointed out that wasn't a condition on the acquisition of firearms. In fact, you were required under the militia laws to bring the firearm that you already had to the militia when you're mustered. So that didn't go anywhere, and the court properly rejected that, and not even the dissent took issue with that. And they also argued that this was designed to keep people who are dangerous from acquiring firearms, but the majority quite properly said, well, this applies to everybody, not people who have been convicted of a crime or otherwise committed anything that's dangerous to the public safety. And so that analogy failed because the how and why the Bruen requires people to focus on has nothing to do with that kind of regulation. So, I mean, if you apply Bruen by virtue of the test it sets out, the result in this case should have been an easy result, and I think that's where the majority was correct. And it is an easy result.
Yeah, I mean, I think you described how this came out pretty much the way I would describe it too, in terms of what the majority's reasoning was there and what the state's arguments were. I am interested though in one section of that dissent got into an issue that I've seen that I've been wondering about from Bruen, and especially from the dissent, the concurrence from Justice Roberts and Kavanaugh, that effectively defended shall issue gun carry permitting, because as the dissent in this case points out, Bruen puts gun carry on the same plane of protection as gun ownership. And at the same time, you have there's a footnote in the majority opinion, and then there's the concurrence, which I think is more relevant. At least sort of for tea leaf reading of where the court might go. But regardless, that the concurrence talks about how shall issue permitting could potentially be all right under the Bruen test for gun carry. And so that kind of implies that perhaps it's okay as well for gun purchasing. And so, what do you think of that argument? What was your response to it? How do you see that, playing out as you pursue this case further?
So I think you're talking about footnote 9, majority opinion, and that is what the concurrence talked about.
Yeah,
Justice Kavanaugh and the Chief Justice, and that was in the context of vast majority of states, I think 42, actually had shall issue permitting systems for public carry, right? And that was very. They
do now, yeah.
Well, then they did, and now of course.
I just mean they didn't at the founding era. Obviously, there was no gun carry permitting.
They didn't at the founding era, but the court does this from time to time. I've been litigating in the Supreme Court a very long time, and sometimes they simply say, well, these are the parameters of our opinions, and this is what we're going to say in footnote 9 about the parameters of opinions. And I think what the court felt, and this is my supposition, is that this has been adjudicated by the states in such a way over time that there's a broad consensus with 42 states that this is something that can be reasonably required for carrying in public. None of those states, by the way, had this sort of arduous permit to acquire system. Not one. Maryland, at the time this case was adjudicated, was the only one. And of course, Maryland may issue. So you can't point to any of the 42 states and say, well, they applied the same sort of licensing requirement to the acquisition of a handgun or a long gun or any other type of weapon. So there is that distinction right there. And I think the majority picked up on that distinction because as Heller said, the right to defend yourself in your home, which is acquisition would permit, is most acute. And because that's at the heart of the castle doctrine, the common law, where your home is your castle and you don't have a duty to retreat from it, and where an intruder is knocking at your door or busting through your windows. So there are different considerations in terms of defense of oneself in the home and of the home, and then defense of oneself outside the home in public, where public safety considerations are more important. And that distinction was recognized in all 42 of those states, because none of them required that. So that's a principal distinction that the majority drew upon in this case, the HQL case. And I think it makes a lot of sense, too. So you throw that into the fact that 42 states had drawn that distinction, and I think the court was willing to accept that. You can say, well, there's no history on that. And they probably felt it had been adjudicated to be reasonable and consistent with the Second Amendment in all these states. So they were willing to accept that without going into what the history of that is.
That's an interesting argument. Yeah, I haven't heard it put that way before. And the court certainly does, especially in Bruen, focus quite a lot on what the consensus sort of is.
There is, and this is not
supposed
just
to go back to the consensus at the founding, but I do think that they often try to avoid. It does seem to me like the court wants to avoid striking down laws that are either extremely broadly popular or have been around for a very, very long time. That seems to be they're conservative and especially in that particular sense.
The court is always sensitive to the
to
practical implications of its rulings, but this concept of adjudication is well recognized and has been applied in other circumstances in Supreme Court decisions as well. So that's nothing novel to it. So
okay. Well, we'll have to see what they actually do if that question gets presented up at the court.
I'm confident at some point it will be, because just issues being raised all over the country.
Yeah.
And we'll probably have a circuit conflict on it at some point.
Yeah, perhaps even this case itself.
I hope not. I hope this case goes away.
Yes, that would be the best outcome for your members. I imagine is just for this to not go anywhere past this point. But I'm guessing that you think the government of Maryland is going to appeal this ruling, right?
Well, I don't know. That's an interesting question. So
there is some risk to appealing, right?
They have 14 days to decide whether to seek rehearing or rehearing in bank for the whole court. That's set by the Federal Rules of Appellate Procedure. And if they don't within those 14 days, then the mandate issues 7 days thereafter under the Rule 41, and it becomes final. Now, they still have 90 days to seek cert, but there's no circuit conflict here. Now, they can always argue, and certainly states have argued this before, that invalidation of a state statute is sufficiently important to warrant Supreme Court review. But the court has historically looked less favorably on an invalidation of federal statutes than it has on state statutes, because the Solicitor General is in court saying, the world's going to come to an end if you validate this federal statute. You'll see that in Rahimi and the other cases like Range. But state statutes are invalidated all the time. So that doesn't necessarily going to be enough to carry the day with a cert petition in the absence of a circuit conflict.
But, if they went to en banc, I feel like they'd have a decent chance in the Fourth Circuit because it tends to favor the government in gun restriction cases to this point.
Well, we don't know how
they might do that.
We don't know because the Fourth Circuit this is the first time the Fourth has spoken on after Bruen. And I like to think, and cast me as naive perhaps, but I've been doing this a long time, and I think judges feel bound by Supreme Court precedent and bound by their duty to faithfully apply Supreme Court precedent. They're not all completely result-oriented. Some are, for sure, but not all. And I'm willing to believe, in the absence of contrary evidence, that they're not going to go against the Supreme Court on flimsy bases. I mean, it wouldn't make sense.
I think you're right on that. I don't think that courts are entirely polarized in that sense. They're not always ruling the way that you might expect from who appointed them or what have you, federal judges. But so you think perhaps Maryland is not going to appeal? Is that where you're at?
I wouldn't want to venture a guess on whether they will or they won't.
Okay.
It depends more on Maryland politics, I think, than the merits of the case. I mean, we saw Governor Moore say Chicken Little style that the sky was falling, and this president of the Senate, Senator Ferguson, saying, "Oh, the sky is falling." But when you think about it, the public safety implications of this case are non-existent, simply because this is for the acquisition of a handgun for self-protection in the home. And so it's not talking about people walking around in public with this. Mm-hmm. So unless you think guns in the home are a great public safety risk and that everybody should be discouraged and all obstacles erected to discourage that, the public safety implications are pretty de minimis.
All right. Well, for what it's worth, Thomas Lester, who's a spokesperson for the Maryland Attorney General, Anthony Bruen, who's a Democrat, told us when we wrote about this ruling that the Attorney General's office is, quote, weighing options for next steps in this case, which prevents us from any further comment at this point. So publicly, I don't believe they've said anything about what they will do. And I guess we'll just have to wait and see on that one. But that is not the only case that you have won recently, right?
Right. We won a case in Montgomery County Circuit Court, State Court. Montgomery County, after Bruen was decided, oh my God, we can't have this. So they did in New York or in New Jersey and said, we're going to enact a local ordinance that said, you guys with permits are no longer going to be exempt under our statute, which was the current law. You're going to be subject to everything. And we're going to define sensitive places to include every place within 100 yards of this list of 15 places. And the 15 places includes churches, private schools, regardless of whether the property is privately owned or publicly owned. And on the literal language of the ordinance, it doesn't even matter whether the place is otherwise open to the public. So in one of the places, for example, that was banned is a library, privately owned or publicly owned library. And if you have a private library, and I'm sitting in one right now, well, arguably that's a prohibited zone now. Now they made an exception for possession inside the home. I mean, actually inside the four walls, not on your property. Maryland law allows you to possess a handgun without a permit on your property, real estate that you're actually on, but not Montgomery County. It has to be within the four walls. So if you stepped outside your door onto your property, you could be in violation of this ordinance. And then they have this 100 yards within all these places. And if you look on the map, and you use Google Maps for this, you can identify all these places that they have, and there are thousands of them. I mean, literally, there's 693 parks in Montgomery County. And they range from 6,000 acres to a city block. There are 695 churches and places of worship, all of which are banned. That means that synagogues that have been using permit holders and to actually provide security and have been given permits on that basis by the Maryland State Police back before Bruen was decided, are now incapable of using these individuals to provide security. In fact, they couldn't even carry themselves on those places. So that basically leaves synagogues and churches naked from a self-defense perspective. And you don't have to be very sophisticated to understand that's a problem.
And Montgomery County, for anyone who's not from Maryland or the area, that's the largest county in the state, right?
It's over 1 million people, the largest by population in the state by far. It's got a $6 billion budget.
It's just outside of Washington, D.C. So
it borders Washington, D.C.
A lot of people live there. And additionally, at arguments in this case, at least from what the judge wrote in his ruling, it sounded as though the county admitted that there basically wasn't anywhere you could legally carry a gun, even with a permit in the county, right?
Well, what they admitted was their intention was to make it impossible to carry with a permit. And that's quite true, because you literally could not carry very far without running into one of these 100-yard buffer zones. Like, for example, the buffer zones included most of Interstate 495, which is the beltway around D.C., most of Interstate 270 going north from D.C., all the major thoroughfares in urban parts and most of the rural parts, minor roads as well. But you can't get in and out of the county without covering a buffer zone because so many of those portions are covered with parks. So it was basically intended to, and did quite successfully, make it impossible to carry with a carry permit. And what the judge,
so a very big impact there. I think there was also a ban on the possession of unserialized firearms.
Yes,
that you make it, homemade guns, ghost guns, it was called,
and components, by the way, which they define to mean the barrel of a long gun, the slide or cylinder of a handgun. In other words, if you could take your serialized handgun, bought at an FFL, perfectly legally, and break it down for cleaning, all of a sudden you have a prohibited component.
Right. Because it doesn't have a serial number on the barrel.
And that's, of course, not a firearm under federal and state law. Right. Those components aren't. And they reserve the exception to the home exception to firearms. So you literally couldn't possess a component in your home under the literal reading of the ordinance. I mean, that's how ignorant Montgomery County is about federal firearms law.
Yeah, so a very poorly written ordinance. But I guess this was blocked by the judge, not on Second Amendment grounds, but on state preemption grounds. There's a law in Maryland that says localities cannot make their own gun laws, that it's a state, the state has to make them. Right, that's the basic ruling. There
is a broad preemption provision, and there are exceptions, which is what the county was relying on. But separate and apart from that, that's provision, which is a broad preemption. There are 5 other statutes which broadly preempt local regulation of regulated firearms, which in Maryland are handguns, and broadly preempts localities from regulating the transfer of long guns. And there is also in Maryland law a implied preemption where if the state has a comprehensive system of regulation, then the court will apply a preemption of local regulation to the extent that it attempts to regulate in that area. And the judge found, and quite correctly, that Maryland has an extremely comprehensive system regulation of all kinds of firearms, long guns, handguns, you name it. So it was not hard for him to find such a comprehensive system, nor was it difficult for him to find, with all these existing laws on the books, that the Maryland law, the county ordinance, that is directly conflicted with it. So that was the basis of the court's ruling.
Yeah, so a significant win for you guys in that case. Where does that stand now? Is this, they're still waiting for the injunction to be
So the opinion that
issued?
came out directed the parties' counsel to meet and confer about the wording of the actual declaratory judgment order and a wording of the actual injunctive order. Mm-hmm. There are 2 separate orders in Maryland. And a third order certifying the case for immediate appeal, because the opinion didn't dispose of all the claims of all the parties, and thus was otherwise non-final, so it couldn't be an appeal until they had a final order. So, but you can certify it for immediate appeal, and that allows the parties to take an appeal. And so he's indicated a willingness to do that. We asked for that, and the county did not object. So once those orders are entered, and we haven't yet conferred with the county yet, but we have 10 days to do that. I'm actually in the process of drafting those up now for submission to opposing counsel for the county, and we'll hammer something out, or if we can't, we'll present the disagreement to the judge, and he'll issue the orders in due course, because it's now mandated by his opinion. So that shouldn't take very long.
And so there is a state version of this Bruen response policy, right?
Oh, yeah.
That has passed recently as well. What's the status of that one?
That's Senate Bill 1. That's sensitive areas legislation, and that created a whole host of sensitive areas for permit holders, where permit holders were not allowed to carry that was much more narrowly drawn than the Montgomery County ordinance. For example, it didn't have buffer zones.
But it still has a pretty significant impact, right?
Well, it did. And one of the things that it provided was the presumptive ban on carry on private property, otherwise open to the public.
That's the vampire rule, people call it.
The vampire, or I call it the Home Depot rule. So it's provided that you could take your handgun with a permit into the parking lot, but not into the building. So you had to leave your handgun in the car if you were going to Home Depot and buy something.
Right.
And another provision that said you can't ever bring your handgun or any firearm into a place that is licensed to sell alcohol for on-site consumption. Alcohol and cannabis. Apparently that's where Maryland's going, is on-site consumption of cannabis. That was struck down by the district court sitting in Baltimore, a different district court. And both of those provisions were struck down, and along with another provision under Bruen that said that an existing state statute that banned carry within 1,000 feet of a public demonstration also lacked any sort of historical justification. And he struck that down from existing law. Now, that was a motion on a preliminary injunction, which, but he didn't, that's immediately appealable. But the court also denied without prejudice, which means that it's not a final ruling, the cross motions for summary judgment that were also filed on the same basis. And so what the parties agreed to do, in light of the PI order, was that the court should now decide the cross motions for summary judgment. The parties did not require any discovery, did not require any further briefing, and that the court could proceed to decide the summary judgment motions without further delay. That is beneficial for both sets of parties because you're no longer appealing a PI, which has a different standard of review. You're appealing a final judgment on the merits, which eliminates a lot of issues for both sides, because will appeal and the state will appeal, and neither side wanted to deal with the PI aspects of it, which is an abuse of discretion standard of review. So the judge
just moves the case along faster, basically.
It will, a lot faster. And we'll get it up to the Fourth Circuit that much faster. So.
But you won on, so you basically won on all these cases at this point.
We won partially on the SB1 case. We didn't get everything we wanted. Like we asked for a PI on the existing ban that predated SB1 on parks. And the judge said, well, it relied on a district court decision in the Montgomery County case, which is interesting. The federal Second Amendment claims in the Montgomery County case are in federal court, and the state claims on preemption are in state court.
Right.
So on the preliminary injunction motion that we filed in federal court under the Second Amendment against the Montgomery County ordinance, making the same arguments, basically accepted under the Second Amendment, the court denied that preliminary injunction, and that's on appeal. We have an immediate right of appeal, and that appeal has been fully briefed. In fact, I'm going to be arguing that appeal on January 23rd. In the Fourth Circuit.
So you're going after it for both for violating state preemption and for violating the Second Amendment.
Right.
You weren't successful on the first phase of the Second Amendment claim, but you've been successful on the first phase of the preemption claim.
We've won completely on the preemption claim, so it's not even a phase; it's a separate.
But it could be appealed, is what I mean.
It could be appealed. Certainly, they can. The state can appeal that.
We don't know yet.
Go to the state Supreme Court eventually, and of course, the denial of our PI on the Second Amendment goes to the Fourth Circuit, Federal Court of Appeals.
So, just to bottom line everything, because I know we're going to move on to the news update soon here. You've won these in these rulings. You're still waiting on the actual injunctions to come down in most of them. What about the federal case against the state law? Is that in effect right now? That injunction?
That injunction is in effect.
Okay.
So people with carry permits are now permitted to carry in private property that is otherwise open to the public. Are permitted to carry in restaurants that serve alcohol for on-site consumption, and are permitted to carry within. You
can't drink, of course.
But you can't drink. Right. The booze and alcohol.
I don't think anyone has a problem with that particular restriction, but yeah.
No, we had no problem. We satisfied. We said the state has an existing law on that very point,
right?
And we're fine with that.
Okay, so that's in effect. People are feeling that effect. They will soon feel the effect of these other two cases, and there's potential that all of them are going to potentially be appealed. We don't know yet. The state law, SB1, that's very likely. That's already in the process of being appealed. Is that?
No, it won't be appealed until the judge actually enters summary judgment. Both parties have said to the judge, this Judge Russell, federal Judge Russell in Baltimore, that we're not going to appeal the preliminary injunction order.
They want to appeal on the merits, but it hasn't actually happened yet. But
it hasn't happened. When he enters,
all these could be appealed, I guess is what I want to
get
to the bottom line.
So, this is, appellate advocacy.
People need to keep paying attention to this stuff is, I guess, my ultimate point.
This is complicated.
Yeah.
So when that summary judgment is entered, I'm sure that will be appealed. I'm sure the state will appeal it. I'm sure that we will appeal it because they lost in part and we lost in part, and we can appeal that.
Right.
So that will be in the Fourth Circuit. But the Montgomery County case, which has already been fully briefed and will be argued in January, will probably come first. And that's the sensitive areas type of analysis at issue there.
All right. Well, we will probably have to have you back on in the future then to round these up once they get to their final destination, which honestly, for some of them could take, these cases sometimes take years. So hopefully, you'll be able to keep those injunctions in place for your members, as I imagine is what you're hoping in the meantime, at the very least. But yeah, no, we appreciate you coming on and explaining all this, because I think it's a good time to update on what's going on with Maryland, because we've got you've had a lot of cases going, and now you've gotten two in a row here where we actually got opinions and they came out in your favor. So I appreciate you walking through that with us and explaining the different arguments at play and how they came out in each of those cases.
And Stephen, it's not just Second Amendment. We have a First Amendment appeal that we're arguing in the Fourth Circuit next week. And that affects what you can force firearms dealers to publish. Because in that case, the county has forced them to publish the suicide pamphlets and conflict resolution pamphlets to everyone they repurchase. And that's compelled speech under the First Amendment and grossly unconstitutional. Yeah,
so we'll have to keep an eye on that one as well, especially when we get a ruling in that case. We'll have to update everyone. But yeah, we appreciate you joining the show, and we'll have to have you on again, because this is, like I said, this is something people need to, especially if you're in Maryland or you ever want to carry a gun in Maryland, because you live or work nearby. You gotta keep up with it. For sure, just like any of these other things. So where, by the way, where can people go and find more about Maryland Shall Issue or follow your advocacy?
Well, we have a website like everyone else. It's the Maryland Shall Issue, all one word, .org. So if you go to that website, within that website, we have long articles on all of these cases. We have documents associated with each one of the cases that you can download, and they're free and access to everybody. You don't have to be a member. We have a big red button at the top that says please join, or donate, because guess what? Litigation ain't cheap. I work for free. Unless we win, I don't get paid. And if we win, the defendant pays. So that's as it should be. That's the fee shifting statute, section 1988. But in the meantime, it's all pro bono. So all the people of MSI's officers and directors are all volunteers. So we punch well above our weight for a bunch of volunteers.
Wonderful. Well, we're going to head over to the news update now.
Great. Thank you.
All right, ladies and gentlemen, welcome to the weekly news update. I'm contributing writer Jake Fogelman, joined as always by Reload founder Stephen Gutowski. How are we doing this week, Steve?
I'm doing pretty good. How you doing, Jake?
I'm doing pretty good. My Broncos are finally rolling, so I'm excited to see if that momentum can continue. We're looking like maybe a wild card team, which is pretty big news here in the city of Denver.
Yeah, pretty weird. Good for you guys. So is it 5 in a row?
Yeah, 5 in a row, and against pretty good teams at that. So everyone's back on the Russell Wilson train after wanting to run him out of town for the last year.
I guess he's not washed like everybody thought. We'll see if they can keep it up. But yeah, the Eagles are 10-1, right?
Yep.
And they're underdogs to the Niners at home.
Oh, really? I didn't see that.
Yeah. They started at 3-point underdogs. They're 2.5-point underdogs, which I think is just, honestly, it's a good thing for us because it's, I think when you're 10-1 and you've beaten like all the good teams in the NFL, right? They beat the Chiefs. They beat the Bills last week. They beat the Cowboys. It's probably hard to stay like motivated in that sense of, or not get too high on yourself. And so if Vegas gives you, makes you dogs at home when you're 2 games up on your opponent, I think that probably gives you some motivation.
It's a return of the everyone hates us and we don't care era is coming back.
Yeah. It's crazy that you can get that sort of, one of the big things in the Super Bowl run, right, was that they were underdogs the whole way because Wentz got hurt and then Foles came in, and we all know how that ended up. But it's kind of lucky to get, when your team is that good, it's a Super Bowl caliber team, you can still pull that motivation of being underdogs because doesn't happen very often, I feel like.
Right.
So yeah, it's almost like a lucky thing. Well, I mean, obviously the Niners are a great team, so they could win. But I'd rather go into the game being an underdog because it gives the guys a little more energy, I think, and especially this team because they're like, the Super Bowl run was built around that whole concept. So you make them underdogs. They really like that. They have there's a bunch of sayings, shirts with the, hungry dogs run faster kind of thing. So I don't know. We'll see. I do really want them to win because I find the 49ers, the players after that loss in the NFC Championship to be like some of the most whiny stuff ever. I don't want to alienate too many people who listen to this that aren't Eagles fans, but because I'm sure Cowboys fans don't like when we talk about this, and Niners fans won't like it either. But yeah, I'm just like, they're still talking about it. They lost. The game was 31-7. Like it wasn't some close game and yeah, of course they lost their quarterback, and maybe it would have been a very different game if they hadn't. And we'll see how this game goes. But man, they really all acted like they would have blown us out, but they got blown out. Anyway, whatever. Moving on from polarizing sports talk. Are you doing any shooting or anything like that coming up here?
Probably not this weekend. I'm doing a little bit of a delayed Friendsgiving this weekend, so that'll probably take up most of my time. So no shooting. What about yourself?
Yeah, the Guns Out guys, we've profiled them, had them on the show before as well. They've opened like a new range here in near Quantico, Virginia. And that looks really cool and exciting. So I'm hoping I don't know about this weekend, but I'm hoping in the near future I can go down there and try some stuff out. It's an outdoor range, so it's a private range, so it's not public, but they're going to use it for exclusive events and stuff. We might do some reload events if that makes sense. So I'm looking forward to trying to figure out some of those details. But I also just want to kind of go down and try out the range. It's outdoor. It has steel. It looks really nice. And we don't have anything like that in Northern Virginia until you get like all the way out to the border with West Virginia. So I don't know. Look, it seems pretty cool. I'm pretty excited about it. And I like to see those guys doing well because they're good dudes, Shermichael and John. So I'm hoping I can put together some time with them to go down there and try out their new range.
Yeah, that does sound cool.
Yeah. But what do we got in terms of news?
Yeah. So in terms of links in the newsletter, we have an interesting investigation from ABC News. They looked into sort of the aftermath of the Lewiston, Maine mass shooting, and they discovered that the use of the yellow flag law that was under so much scrutiny for obvious reasons in that shooting is way up. It's been used 36 times since that shooting, which they found out was about 30% of the total times it's ever been used in its history, just in the last, few weeks or whatever. So clearly that incident put a spotlight on that law, and police are using it more now.
Yeah. I think that's part of it, right? Just people are more aware of it after a big news event happens where it gets talked about a lot. So you get probably more requests for it to be used. And then also, I think Cam Edwards talked about this when we discussed red flag laws on the show a while back. You know, one of the critiques of them is that they're likely to be abused, or they're likely to be at least issued in most cases, because the judges or law enforcement who are requesting them, they don't want to be the ones who sort of let something fall through the cracks. So they're going to be really overly broad in the application of it. That's one of the critiques of red flag laws. So that may be playing a role here as well. So yeah, you have both increased visibility of the fact that this law exists and how to use it, which I'm sure most people, your average person who lives in a state that has one of these laws, probably doesn't understand any of that. Especially because they're still relatively new things. You know, the big push for red flag laws was in 2018. It's not that long ago. There were a couple states that had them before then, but most of them have been adopted since then. And so people are just not as aware of them as, you know, especially compared to like me or you or people who listen to this podcast who are very up on gun policy stuff. But so, yeah, I think that's part of it. And then, yeah, there's probably less the authorities are probably much more likely to go through the process after seeing what happens if somebody, what could happen if they didn't do it.
Yeah, I think that's right. The other story from the links that we want to bring up is we have a story from Reuters about the National Association for Gun Rights, or a gun rights group that is challenging Illinois' assault weapon ban. And they are going back to the Supreme Court to try to get emergency intervention on that case once again. So they did this previously and the court denied their request. They're trying once more. So that's interesting to see if the court is willing to, take the unusual step of intervening.
Yeah, they're going back to the ghost docket, which is what people call this. These emergency requests. It's done, not through the normal chain of appeals. This is something where you can immediately ask the Supreme Court to intervene, and you've seen that a couple of times since Bruen in a number of gun cases. And the court has denied all of these for gun rights plaintiffs, usually because my understanding at least is that it has to do with, the court is more reluctant to issue injunctions on the emergency docket like that. They seem more inclined to issue stays of lower court rulings, which they also did for a gun case for the ghost gun ATF ban. They've intervened there on using the ghost docket, the emergency docket, to say that a stay should be in place while this case moves forward. They haven't gone the other route to say an injunction should be in place to block a law while the case moves forward. So it's probably a long shot given what the court has done so far, but we'll see, right? There's certainly a possibility. I think the merits of the case, this is the assault weapons ban case against a specific city in Illinois, separate from the statewide assault weapons ban case that is also percolating through the courts. The lower court has upheld the ban using logic that I think the Supreme Court itself is unlikely to agree with. So there's some chance that they might feel inclined to step in on an emergency basis, but it definitely is more of a long shot. They have, I think Justice Amy Coney Barrett is the one who oversees this circuit. And so she's referred this request to the court, and she's asked for a briefing from the city, which is what you typically see in these sorts of events. So the court is going to discuss this at least and decide whether they want to intervene.
Yeah. Like you said, it's probably a long shot, but it's certainly worth keeping an eye on just because of how high profile the issue is.
If they do step in, that's a huge, huge deal.
Certainly. And heading into some of the stories we wrote up this week, you had one actually about Black Friday and gun sales, and we actually got some surprising results about at least what looks like a really big Black Friday for gun sales. If you want to tell us what your reporting found.
Yeah, it was the best ever. Well, we shouldn't say gun sales, I guess, because
Sure.
We want to be really careful about this, because what we're actually reporting on here are background checks from the National Instant Criminal Background Check System that the FBI runs. And yes, those are obviously associated with guns in a couple of different ways. And one of the most significant one, if you're trying to track gun sales, is background checks on gun sales. But we report on these numbers a lot, right? In fact, we should be getting the new numbers for November relatively soon, now that we're here in December. And, this is, that's generally based on an industry analysis. The National Shooting Sports Foundation, which is the industry's trade group, will go through the more detailed release that the FBI puts out every month that codes the background checks on what kind of check it is, because it's not just gun sales that they check. They also check permits, right? And some states will, so the raw numbers can be way out of whack with what gun sales numbers are, or checks on gun sales specifically, because some states will actually recheck all of their permit holders every single month. I know that Illinois does that. So Illinois has hundreds of thousands of NICS checks each month that have nothing to do with gun sales. And these numbers aren't one-to-one anyway, because some states allow you to bypass a NICS check if you have a concealed carry permit. They'll do it as a permit check. So sometimes permit checks can be actual gun sales. Anyway, you get the point here is that these numbers aren't, even the best at times aren't total perfect analogs for gun sales. But you aren't able to do that kind of analysis, that kind of breakdown with the numbers that the FBI puts out for Black Friday. They just give you a single number. Now, it's still an apples to apples comparison to other Black Fridays, because that's how they've always done it. And this Black Friday saw the most background checks of any, which does probably indicate that sales were up. And that comes after we saw October's sales were up year over year, which is something that we hadn't seen very often, right? I think there's only been like maybe 2 or 3 months this year where gun sales were up over the previous year. The rest of them saw significant declines. And so that could be an indication that we've been talking about this for years now, but the industry is looking for that floor, that sales floor. Where is this going to settle out after the huge surge we saw in 2020 and 2021? Sales have been declining ever since then, but which is typical. The industry goes in cycles, and they tend to be cycles surrounding some sort of chaotic event, or in the case of 2020, multiple chaotic events. Right? It was kind of the perfect storm for motivating people to go buy a gun, and especially because you had all sorts of different incidents that motivated all kinds of different people with different belief structures and backgrounds to go buy guns. But regardless, we've been waiting. The industry and observers have been waiting to see, where is the new floor going to be? Usually it settles out a bit above where the old highs were. And we are still at that point, even though this year is likely to be down a bit from last year. It's still above 2019 and all the Trump years, essentially. So, other than 2020, of course. But yeah, it's just one piece of evidence, but it's a notable one. The biggest Black Friday ever for NICS checks is pretty notable.
Yeah, certainly. And, we'll of course be keeping an eye on this as things move forward, just trying to figure out where that trend's going and like you said, where that new floor is. Yeah. And the last big story we want to talk about this week is a new bill that's been introduced in the U.S. Senate. It's by Senators Angus King from Maine, the independent from Maine, and Martin Heinrich from New Mexico. They introduced the Gas-Operated Semi-Automatic Firearms Exclusion Act, or GO-SAFE Act. Basically, it's just another attempt at an assault weapon ban, but they went about it in a pretty novel way in terms of how they're defining the weapons that will be banned. So, yeah, pretty big deal that they're going back to the well for an assault weapon ban, and it's interesting the way they're going about it this time.
Yeah, definitely. And it's particularly interesting because of who's involved, right? You had King and Heinrich. You also had Bennett, and there was a fourth. Who's the fourth?
Mark Kelly from Arizona.
Yeah, Mark Kelly from Arizona. Now, it's interesting because these guys have had a reputation of being more moderate as far as Senate Democrats go on gun policy. King was involved in blocking Chipman from becoming the ATF director. These other guys have not made gun control a major part of their platforms, although obviously Mark Kelly is married to Gabby Giffords, who runs a gun control organization. And I will say that all of them at some point have supported assault weapons ban. So it's interesting, right? Because they're certainly not the people out in front of this issue generally.
Right.
And that's one thing that makes it newsworthy to me.
Right. It's not Chris Murphy, for example,
Right. Exactly.
Yeah.
At the same time, it's also not, John Tester or Joe Manchin or Kirsten Sinema. So they don't have those people on board. They don't have any Republicans at this point. And I do feel like if they were likely to get somebody like Susan Collins, the other senator from Maine, on board, they would have already done that. Now it's not impossible she joins now that they've announced. Maybe they just didn't coordinate things very well. That seems unlikely to me. Like they probably did try to get her on board, and she's not on board. So they have no Republican support. They don't even have the most moderate of Democrats on this issue, Tester and Sinema and Manchin on board. So it tells me that they probably don't even have 50 votes for this. Even still, that's why the assault weapons ban that passed the House last year never came up for a vote in the Senate. Most likely not because of the filibuster, which is what gets blamed, but because they probably don't have 50 votes for one. And this does seem, as you alluded to there, as a kind of a rebranding, a tactics change to try and jumpstart this in the Senate among at least Democrats, try to get all 50 Democrats on board, or 51 Democrats on board at this point. And I don't know we'll see if it works, but that's, I think, what makes it particularly interesting. But yeah, also what makes it interesting is just the way it's written, as you're getting at. Like, you did a whole analysis piece. Let's just walk through real quick some of the oddities in this bill. Like what is, I mean, and this is going to be hard to explain to somebody who actually knows about firearms terminology, right? Because you heard from the name, right? They put in gas operated as part of the definition. And Angus King is going out. He was on MSNBC and he was selling this as kind of less a moderate approach to assault weapons bans and more like a response to some of the common criticisms of assault weapons bans being focused on cosmetic features or ergonomic features, things like pistol grips or telescoping stocks, stuff like that, is what has traditionally made a type of semi-automatic rifle banned. But instead, they're focused on, they really just don't have any feature exceptions is what they do. And they try to imply that this is based on the operating system of the gun, gas operated, right? But the problem, well, I guess I can let you explain. What's the big problem with that? How do they define gas operated?
Yeah, so essentially their definition of I can actually probably read it to you here, but essentially for all intents and purposes, their definition of gas operated is essentially just semi-automatic. It says a gas operated semi-automatic firearm is one that, quote, harnesses or traps a portion of the high gas pressure from a fired cartridge to cycle the action. Which, I mean, that's how all semi-automatic firearms operate, right? To one extent or another.
But that's not the definition that most people who understand guns would use for gas operated. Gas operated, they do lay out like piston driven, gas operated, direct impingement, gas operated guns in their part of their gas operated definition. But the problem is then they also include things like blowback and recoil operated guns, which traditionally in the gun space, at least, they aren't considered to be gas operated because they're not using, siphoning off some of the gas from the that's expelled when you shoot a round to actually operate the gun. They rely on just strictly the forces being propelled backwards, recoil or blowback.
Right.
You could all these things you could say in theory are involved the gas being expelled when you fire a gun, but that's not how it has traditionally been broken down for most people who talk about this level of gun knowledge, right? Like if you're watching Forgotten Weapons or some Ian McCallum over there, that kind of stuff, you're looking at how the gun actually operates. Gas operated doesn't usually mean, people don't take that to mean recoil operated or blowback, but that's what this bill does define it that way. But and so it sort of essentially bans any semi-automatic rifle, right? That can accept a
basically
detachable magazine.
Right. Essentially, the definition bans all semi-automatics, but to get around the controversy of, obviously, I think that would be a bridge too far for most people.
Yeah.
They just put in exceptions in there to say, well, we're not talking about semi-automatic shotguns. We're not talking about recoil operated handguns. So by their definition of what's banned, it's all semi-automatics. But they're like, but this doesn't apply to these things that also fall within this definition, but we don't care about those as much. So that's kind of how they get around that.
Yeah, that's exactly right. It basically bans any semi-automatic that can accept a magazine. And then it makes a bunch of exceptions for all. I mean, there's some really broad ones. Like you mentioned, all semi-automatic shotguns, for whatever reason, are exempted regardless of how they operate. I don't know why. And then some semi-automatic handguns are accepted, or I guess most of your popular ones,
right?
Recoil operated. So your Glocks and your Smith & Wesson M&P line, or your SIG 320s, whatever, stuff like that. Although it would still ban a bunch of other stuff, like even like a high point, right? High points are straight blowback guns. That's why their slides are so thick, because it only exempts recoil operated.
That's right.
Your Browning tilt action guns, your 1911, stuff like that. Anything with a fixed barrel, like even like so really high end stuff like the Lago Alien would probably be banned under this, because it's blowback with a gas delay system, and we're getting really into the details of this, but it's just kind of funny because it's like you read this bill and it's people, whoever wrote this, it's like they looked up some terms, didn't really understand them, and then just tossed them in here. Because like they exempt things for some reason. They go out of their way in the semi-auto ban to exempt things that aren't semi-automatic anyway. Like bolt action handguns are exempted, written into the law as an exemption. It's pretty bizarre the way they did this. And you have a lot more detail in your members piece, which, by the way, our Black Friday sale is still going on. It'll end on Monday when this goes public, but people still have a chance to go and buy a membership for 20% off. We don't do those sales very often, so I would say take the opportunity, and you can go and read every weird detail about this bill, because there's a lot more than what we're getting at here.
Yeah,
they even go after, there's this sort of bump stock ban written in here, and it exemplifies exactly why there was concern about doing that legislatively in 2018, or after the Las Vegas shooting, because the way they've written this into law could certainly be construed to ban basically any modification to any semi-automatic of any kind. They don't, for some reason, they don't include gas operated there. It's just semi-automatic. So it would include your regular Glock or Smith & Wesson handguns, and anything that makes it fire materially faster. So yeah, I would imagine that would include things like upgraded triggers, stiffer recoil springs, even a grip, perhaps. You change out your grip module and you can shoot faster than you could before because you can get a better grip. That materially increases the rate at which you can fire the gun. Now, it doesn't change the cycling speed of the gun, right? But the goal here seems to be more about your ability. I mean, the bump stock doesn't change the cycling speed of a gun. It just lets you pull the trigger faster than you otherwise would be able to. So yeah, and there's even more than that. There's a whole private right of action. If the AG gets a lot of power in this to just decide what they think are gas operated guns, semi-automatics that are subject to this ban. There's a whole bureaucratic process put in place for that. And there's even a private right of action for opposing the attorney general if you think a gun should have been on the list and it was taken off. So there's a lot. People should go check out your piece about it. It's a very odd bill.
Yeah, it's an odd bill. People should check it out. Like we said at the top of this segment, it it's probably dead on arrival. It's not going to pass at least through the 2024 election. But the fact that they went to this strategy, I think is at least noteworthy, that people should, it's important as a story for people to see the strategic, because obviously assault weapon bans have been introduced for, since the 90s.
Yeah.
And
they've
it
kind of
hasn't
been
gotten
stalled
anywhere.
since then. Yeah. I mean, you've had
Right.
a couple in recent years. You've seen like Delaware and Illinois.
Sure,
pass
at the
them.
state level, they've passed the traditional ones, but obviously at the federal level, it's gotten nowhere. And so to see a new strategic attempt to try to repackage one, I think is noteworthy, because maybe it could be a new trend. So
Exactly. And that's why we covered this, right? I mean, because we don't go out and cover every bill that gets introduced.
right.
There's lots of gun related bills that get introduced all the time. There's even some that come up for votes. We don't necessarily spend a lot of time covering them because they're almost exclusively messaging bills, and they aren't really any different from the last time that the Congress sent the same message. There's stuff like that happens. We don't cover it. And so we have to, pick and choose what we think are the most important pieces each week. And this was one that made the cut just because of the people involved more. It is a novel bill. It takes they're trying to get to the same place as an assault weapons ban. But it takes a different approach. Does have the benefit of being a bit goofy. So you can kind of be like, this is weird. that makes it a little more interesting too. But primarily it's like you said, there's a political aspect to this that I think makes it newsworthy, beyond what a lot of other bills that get introduced are. Like if Murphy had introduced this, it might still be vaguely interesting and worth talking about if it was just because of the intricacies of how the bill works. But because it was King and these other three moderate-ish Democratic senators, it does become, I think, a bit more worth looking at, even though there's no chance it becomes law before the next election, because this could be the way that they move forward. It seems like it certainly seemed designed as a response to common critiques of assault weapons bans, that they're too focused on cosmetic features. It doesn't do a particularly good job of responding to those critiques, I think, for some of the reasons we laid out. But it does seem to be that, and maybe they'll refine it further, and they're so this could be the start of that kind of trend too. It's just something I think ends up being relevant enough for us to write about and to talk about. But if people want to read more about it and look at the text of the bill, they can head over to reload.com. They can pick up a membership to read your member exclusive piece on it, as well as hundreds of other member exclusive pieces that we have available only to our members. Of course, if you buy a membership, you will also get this podcast a day early and the opportunity to appear on the show in a member segment, which I have one scheduled coming up here soon. So I'm looking forward to that. And of course, you'll get the ability to comment on all of our stories as well. That is another member exclusive perk. And you will get a Sunday newsletter that is only for members. That gives you all of our member pieces for the week and a little bit more analysis and insight into what's going on with Guns in America, but also with what we're up to. Put updates about the farm and stuff in there too sometimes for members who like to read that kind of stuff too. But it's a good deal, and I think right now is the best time to buy because it's 20% off if you go over to the reload.com right now and purchase membership. So that's all we've got for this week. We will see you again real soon. If you like the show, please share it with people you think might be interested in it, or leave a rating of wherever you're listening to this, or leave a comment on YouTube, thumbs up. Anything helps. We appreciate it. But we will see you guys again real soon.